Imagine applying for a job, right? And the HR department tells you, great, we have your application. We will finish processing it in the year 2199.
Yeah, you would immediately assume that's a glitch in the software.
Exactly. I mean, nobody waits over a century for paperwork to clear. But according to the Department of Homeland Security's own mathematical projections, a delay of up to 173 years is exactly what they're proposing for hundreds of thousands of people trying to enter the legal workforce.
It is wild. I mean, it sounds like hyperbole when you put it in terms of centuries, but, we really are looking at a fundamental rewiring of how the United States manages its labor pool.
We absolutely are. So welcome to today's deep dive. Whether you are, an employer trying to manage a workforce, someone closely tracking immigration policy, or just a curious mind trying to cut through the noise of all these complex headlines, we are really glad you are here with us.
Yeah, thanks for joining us. There is a lot of ground to cover today.
There really is. So our mission today is to tear this new proposal down to the studs. We're looking at the Department of Homeland Security's newly proposed rule, which was published in the Federal Register on February 23, 2026. It's titled Employment Authorization Reform for Asylum Applicants.
Right, and we should probably make something super clear right up front.
Yes, the impartiality disclaimer. Because the source material obviously touches on some highly politically charged themes, our goal today is strictly impartial reporting. Neither of us will be endorsing any political viewpoint.
Exactly. We're just here to explore the facts, the actual mechanics, and the projected impacts exactly as they're presented in the sources. No spin.
Right, just the data. Okay, let's unpack this. To really understand the sheer scale of the changes being proposed here, we need to establish our baseline. So as of today, March 15th, 2026, before this proposal takes effect, what are the current rules?
Okay, so under the current rules, this is category C8 for those tracking the codes. When someone arrives and formally files their affirmative asylum application, they enter a mandatory waiting period.
Right, so they can't just start working on day one.
No, absolutely not. They are legally barred from working right away. So currently, they have to wait a minimum of 150 days before they can even submit the application for their work permit.
Okay, so 150 days just to ask for the permit.
Yeah, and then USCIS cannot actually grant the permit until at least 180 days have passed since the original asylum claim was filed. This is commonly called the 180-day asylum EAD clock.
So you arrive, you claim asylum, and for roughly 6 months, you are legally forbidden from earning a paycheck. You just have to rely on, I don't know, savings or local charity.
Right, community support, exactly. That is the baseline today. But the new DHS proposal completely alters that timeline. The first major shockwave is that they are doubling that initial wait.
Doubling it.
Yeah. So instead of 180 days, an asylum applicant would have to wait a full 365 calendar days after their application is received before they can get work authorization.
Wow. A full year without legal income. That's rough.
It is.
Yeah.
But honestly, a one-year wait is really just the warm-up act in this proposal.
Yeah.
The mechanism that is getting everyone's attention is what DHS calls the indefinite pause.
Right, the pause. Let's dig into that because the math on this is staggering. How exactly does this trigger work?
Okay, so the proposal mandates an indefinite pause on accepting any new initial work permit applications if the average processing time for affirmative asylum cases exceeds 180 days over a consecutive 90-day period.
Wait, let's clarify that real quick. Affirmative asylum cases. That distinction is important here.
It's critical, yeah. An affirmative claim is when someone who is not already in removal proceedings voluntarily steps forward and applies for asylum with USCIS.
As opposed to a defensive claim, which is...
Right. Defensive is when someone is already in immigration court facing deportation and claims asylum as a defense. This new rule ties the work permit pause specifically to the backlog of the affirmative cases.
Okay, I want to give you an analogy to help visualize this because it's kind of absurd. It's like a restaurant manager saying the kitchen is backed up, right? So they lock the front doors indefinitely. But instead of waiting an hour for the kitchen to catch up, DHS's own analysis estimates this suspension could last anywhere from 14 to 173 years.
Exactly. Because you have to look at the current backlogs. The rule says the pause triggers if the average processing time goes over 180 days. But current backlogs are already averaging anywhere from 22 to 35 months.
Oh, wow. So they are already miles past the trigger point.
Yeah, miles past it. If this rule goes into effect, that pause triggers on day one, and lifting it requires getting the average time back under 180 days.
Which, given the millions of cases already in the system, is where they get that 173-year estimate.
Right. When you factor in the intake rate and the physical limits of USCIS staffing, it basically halts asylum-based work permits for an entire generation of new applicants.
But wait, are there other hurdles? Like, even if you miraculously bypass this pause, is the process straightforward?
Oh, definitely not. The proposed rule adds massive new administrative hurdles. For one, it gives USCIS up to 180 days just to adjudicate the work permit application itself.
Wait, so you wait your 365 days, and if there's no pause, you still wait another 6 months just for the bureaucracy to mail you the card.
Yep, exactly. Plus, they're mandating biometrics for a much wider pool of applicants. They're adding new bars for anyone who entered without inspection.
Duh.
And they're giving adjudicators incredibly wide discretion to just deny a permit based on, quote, derogatory information.
So it moves from a simple checklist, like did you wait the required days, yes or no, to this highly subjective evaluation of your entire background.
Right. It introduces immense friction into every single application.
So why? I mean, why pull these specific extreme levers? If you were listening to this and thinking, well, shouldn't we deter fraudulent claims? You aren't alone, right? Because that is the exact foundation of DHS's argument here.
Yeah, the DHS rationale centers entirely on deterrence and system integrity. They argue that the current work permit system acts as this massive pull factor.
Like a magnet.
Exactly. If people know they can get a legal work permit in 6 months just by filing a claim, DHS argues it creates a perverse incentive for frivolous, fraudulent, or otherwise meritless claims.
I see. So people are just filing to get the work permit, not because they actually need asylum.
That's the DHS argument, yeah. To quote a February 2026 DHS spokesperson directly, "For too long, a fraudulent asylum claim has been an easy path to working in the United States. Aliens are not entitled to work while we process their asylum applications. The Trump administration is strengthening the vetting."
Okay, but here's where it gets really interesting to me. Let's look at the mechanics of that deterrence logic. If the system is pausing work permits for everyone because cases take too long to process, how does the system differentiate between a frivolous applicant and a legitimate refugee during those initial years of waiting?
It doesn't. It is a completely blunt instrument. During that decade-long or century-long pause, everyone is locked out equally.
Right. And if you deter a fraudulent applicant, they might just stay home. But a legitimate refugee, by definition, is fleeing for their life. They have to come.
Exactly.
So they get stranded here, totally locked out of the legal economy. What are the critics and advocacy groups saying about that?
Oh, the pushback is intense. Groups like the American Immigration Council, ASAP, the Asylum Seeker Advocacy Project, and FWD.US are warning of severe hardship.
I can imagine.
Yeah, I mean, if you legally forbid someone from working for a decade, you force absolute destitution. People become completely reliant on public resources and strained local community safety nets.
And people still have to eat, right? They still need to survive. So they end up relying on informal, unregulated labor.
Right, the underground economy.
Yeah.
Which makes them incredibly vulnerable to exploitative labor practices, wage theft, all of that.
Which brings us to the economic price tag of this whole thing.
Yeah.
Because the sources mention some absolutely staggering figures regarding lost wages.
They do. Independent economic assessments estimate the annual lost wages from this policy to be around $70 billion.
70 billion. With a B, that is a massive removal of capital.
It really is. And the ripple effects are huge. It's reduced productivity across the board, higher employer costs because they are suddenly competing for a shrinking labor pool, and obviously lost tax revenue.
Because if they are working under the table in a shadow economy, they aren't paying income or payroll taxes.
Exactly. And for employers in sectors like agriculture, construction, or hospitality, which heavily rely on this workforce, this potential sudden loss of workers could easily drive up operating costs, which then contributes to inflation.
So the food we buy, the houses we build, all of it gets more expensive.
Right.
Okay, so we've been talking about this 365-day wait and the indefinite pause as a proposed rule. But the landscape isn't waiting around for a finalized PDF, is it? Things are already shifting on the ground right now.
Yes, absolutely. You really have to view this February 2026 proposal as part of the broader Trump-Vance enforcement agenda, which already includes surging deportations and revetting prior approvals.
So what's the squeeze that's already happening? While everyone is debating this 173-year pause, what interim restrictions have actually taken effect?
Well, there are a few major ones. First, shorter validity periods. As of December 5, 2025, new EADs are capped at a maximum of 18 months.
Wait, what were they before?
They used to be valid for up to 5 years.
Oh, wow. So you have to reapply way more often now, which I assume means more fees.
Significant cost spikes, yes. Historically, initial applications for these work permits were fee-exempt. Now, the initial application is $560.
So you can't work, but you have to find $560 just to apply for the right to work.
Right. And renewals are even worse. They are now $745 if you file online or $795 by mail.
That's brutal. And what about the processing times for those renewals? I mean, I remember there used to be an automatic extension if the government was running slow, right?
There was, yeah. But that's gone. New automatic extensions ceased in late October 2025.
Wait, really? So if your 18-month card expires and USCIS hasn't processed your renewal yet?
You lose your job. Your employer legally has to terminate you. On top of that, there are specific country holds now holds for nationals of countries deemed high risk.
So they are just squeezing the system from every possible angle. But I mean, is this unprecedented? Didn't we see something kind of similar during the first Trump administration?
We did, yeah. The 2020 Trump administration tried a similar, though slightly less expansive, set of restrictions on asylum work permits.
And how did that pan out legally?
It faced massive successful legal challenges. The courts pushed back hard, so it's widely anticipated that the lawsuits for this 2026 rule will cite similar things: violations of the Administrative Procedure Act, due process issues, arbitrary enforcement.
And they'll probably argue that the government completely failed to weigh that $70 billion economic impact, right?
Exactly. That will be a cornerstone of the legal battle.
Okay, so let's give some actionable advice here. For the listener, what are the practical implications right now?
Well, first, the public comment period for this proposed rule closes on April 24, 2026. That is the deadline for advocacy groups, businesses, and citizens to get their feedback on the record.
And what are the applicants who are already in the system?
Generally, for applicants who file before any final rule takes effect, the current rules apply. So they don't face the 365-day wait or the indefinite pause, though they still have to deal with the 18-month caps and high fees.
And employers?
Employers need to monitor USCI statuses relentlessly. With the loss of automatic extensions, sudden workforce disruptions are basically guaranteed.
Right, you could lose a key employee overnight just because a piece of mail is delayed.
If we connect this to the bigger picture, we are seeing a total paradigm shift in how the U.S. manages the waiting period for asylum seekers. It is a fundamental rewiring.
It really is. So what does this all mean for you? We are looking at a system desperately trying to deter fraud and manage a historic backlog versus the profound human and economic costs of sidelining a massive workforce.
It's a huge tension.
Which leaves us with a final thought to mull over. If the system legally bars these individuals from working for years, the need to survive doesn't just evaporate, right? Does this massive policy shift risk inadvertently creating a $70 billion untaxed, unregulated shadow economy right in our own local communities?
Yeah.
And if so, how does that exploding underground market impact the very security and economic stability this rule is trying to protect?
Definitely something to think about. Thank you for joining us on this deep dive. If you or your business are directly affected by these changes, definitely consult uscis.gov or an immigration attorney, as things are shifting fast.
Thanks for listening.
We will be back soon to unpack more complex sources. Until next time.